Honor, you might want to seek the aid of the interpretation.
Council should just stick to what came out and the law so that we are not
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealing with the question of Article 10. I invite you to apply the tool of the Golden Rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Seriously.
Yeah, that's what.
Okay, I'll abandon that, but I know the court has noted. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than to limit it. And that you're being invited by Article 19, 20, and 21 to argue that Section 8 of the Magistrate Code limits you, again, would be to miss the point. There is no possibility that the Constitution can give you, under Article 10, which provides, again about these values, and I want to just mention the value of human rights, that when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill exclusively? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement, invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take it away from you? Then when interpreting that Section 8, again, you must interpret it in a manner that advances the enjoyment of that right, other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, Clause 2, Paragraph B. And this, I'll leave it at this and then invite Mr. Kihara, because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their argument. What we understand, let me finish. Let us just have courtesy. What we understand as a response, let's sit and finish it.
So just sit down.
Yeah. You look that they don't have a place to sit.
No, you We are reading that in response so that we don't meditate, we just issues that have arisen.
Okay, I'll abandon that argument. I'll take that protection. So that, Your Honor, I'll then invite my and try to proceed.
So, Mr. Njiru, before you invite,
yes, sir.
Don't you think if you urge me, as you have done, in view of that Section 7 of the 6th section,
yes,
do you think I'll be cited for judicial office?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
Sorry. This second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
It's one thing to hold a master's and
sorry, yeah, I'm not on trial, Your Honor. I'm asking you to just respect me because I am not. No. Yes, this is the second time counsel is attacking me and I seldom. But I am asking him to respect me because he's my friend.
Okay.
That's not the matter.
Yes, Your Honor.
Mr. Which has demonstrated his credentials.
Yes.
Let's not challenge it.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am not the kind of person to be intimidated by people like Mr. Ndegwah. So this court should just direct him that he respects the court if he doesn't want to respect me. And if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone to just make shades. So please, just respect me.
Let's not insist that I was actually about to praise the council for their appropriateness and their propriety, but now I think we almost descended.
Yeah.
Let's just maintain our cool and decorum.
Well,
You already wound up. I was just expressing that perspective.
Yes, Your Honor. There is no judicial overreach because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial overreach, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most of that.
Thank you, counsel. You're the last one, Mr. President.
I think the chairman has to say just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Witty has a habit of always rising when I rise. If you stand, I can submit when you standing. I don't have a problem. But let me make the submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to reopen.
He has already closed this case.
Yes.
I'll address that. Let's just finish with that.
Okay, that's fine.
Let's finish because they are responding to what you raised.
He cannot be allowed to be sitting.
I think the court has directed.